Good evening, ladies and gentlemen. In this episode, we explore just how corrupt and self-serving the Canadian justice system and its complaint process really is. We all have rights in Canada given to us by the Canadian Charter of Rights and Freedoms, and a large portion of those rights pertain to the justice system. Everyone has the following fundamental freedoms: freedom of conscience and religion, freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communications, freedom of peaceful assembly, and freedom of association. Everyone has the right to life, liberty, and the security of their person, and the right not to be deprived, therefore, except in accordance with the principles of fundamental justice. Everyone has the right to be secure against unreasonable search and seizure. Everyone has the right not to be arbitrarily detained or imprisoned. Section 11D says a fair trial ensures that the rights of the accused are properly protected. But how can we ensure that the rights of the accused are properly protected, you ask? We can't. The fact that our judicial and prosecutorial complaint process are run by the judicial and prosecutorial branch of the government, when judgment is meted out behind a curtain of secrecy and judges and crown prosecutors can do as they please, how are we as Canadians supposed to ensure that there even was a fair trial? Word of mouth? Should we rely on mainstream corporate media for our information? Talk about clicks and views. This is 2025. But our courts operate like it was still 1960. How is this even remotely democratic? Step out into the light of truth and freedom. That light will cleanse you. I hope you all enjoy the video.
Everything comes to he who waits.
Hello, good citizens, and welcome back to Documenting and Exposing West Shore RCMP. This is part 25 2.0. So, my first appearance for my lawsuit for my false arrests was a settlement conference hearing, and part of the audio from that settlement conference hearing was published on my YouTube channel. The Office of the Chief Judge contacted me and said, Dan, we don't like it when you expose our corruption, so you better take that down, or we're going to send a SWAT team to your house in the middle of the night. You might want to sleep fully clothed for the next 2 years. Publishing that was, although I didn't record it, publishing that was contrary to contempt of court, which is the only common law criminal charge in Canada. So, since I don't want to spend 2 to 3 years in prison while they figure all this out, that video was deleted off my channel. They also instructed me to delete any copies on my devices, and any and all copies on my devices have been deleted because I'm not a doing time kind of guy. So if you watched it, great. If you didn't, if you missed it, well, too bad. Long story short, the judge at the settlement conference hearing didn't like the fact that someone showed up without a lawyer, and was way more prepared than she was. And so she got angry with me. She got very impatient with me. She basically turned into what I call the human crocodile cunt. Speaking, of course, of the Honorable Judge Loretta Chaperone, who is, you can see in this image here. This was part of the original Part 25 video. This was the only image of Judge Chaperone that I could find on the internet with this artiste thing here going on. And I went over this kind of interesting little piece that somebody, I guess, runs this site. I have no idea who wrote this, but they said that the Judge Chaperone is still serving as a senior judge and has built up a solid reputation as a fair judge. So anyone that heard that settlement conference hearing, yeah, you were hearing a judge that has built a solid reputation on being a fair judge. So obviously audio recording in a courtroom or in a proceeding, whether it's in your home or wherever, that's not allowed. And there's good reason for that. There's actually a really good reason why they don't allow that. And the reason why is because they don't want you to expose their corruption, their crimes. So when judges and prosecutors commit crimes in courtrooms and court proceedings, you're not allowed to expose that. This is why there's confidential hearings. This is why these settlement conferences are off the record. Another reason why settlement conferences are off the record is because most of the time, when there's a lawsuit in the province of British Columbia, it's actually the government being sued. So the government is allowed to hold a private and confidential hearing with whoever's suing them, and the government is allowed to make them an offer that they can't refuse and settle right there and then, and nobody may speak of it. Again, there's nothing public about it. It's all done behind closed doors. No one's meant to get settlement conference results will never go to the media. It'll never be on the news. You personally wouldn't be able to publish it on your YouTube channel. And as I said, there's a very good reason for that. It's because the government doesn't want you to know about all their corruption, all the crimes that they commit. They want it to be completely secret so that when you or me or someone goes to sue them for something corrupt or criminal that the government did, they can just settle with you and you can't talk about it. You can't go public about it. It's all swept under the rug nicely. And if you do talk about it and you do go public with it, they'll charge you with contempt of court. It's a common law criminal offense. And you could spend up to 2 years in prison. So thanks for your cooperation. Pretty cool, hey? Comply or die. When exposing a crime is treated as committing a crime, you are ruled by criminals. I've said it before, I'll say it again. If I ever go missing or disappear, now you know why. So this settlement conference just basically ended with me arguing with a biased, angry, and impatient judge, and we didn't get anywhere. And because of the difficulty of having this settlement conference hearing over the phone, the judge ordered that all parties are to come back to court and appear in person and start this whole fiasco over again. And according to a follower of my YouTube channel, I haven't confirmed this myself, but I have no reason to not believe this person, a channel that goes by the name of Dan Canada, and I swear to gosh, it's not me. This channel claims that they contacted the phone number associated with Loretta Chaperone's name when you Google her name as a provincial court judge. And I believe the phone number is for the Victoria Law Courts. And according to a comment that this channel left on that video that I had to delete, Loretta Chaperone retired as a judge 5 days after I published that video of her going crazy on me. And I think it was within 2 or 3 days of her retiring, that's when I got contacted by the Office of the Chief Judge to take down the video. So, coincidence? Perhaps. And now, if you watch this channel often, you'll know that I don't make complaints against people that work for the government, or at least I make very few complaints. I make a lot fewer complaints than I should. And there's a reason for that, is because they all get laughed at, they all get crumpled up and thrown in the trash, which to me is just hilarious because, I don't have this, I didn't start this channel to show you guys how awesome I am, or, what a great fake lawyer I am. That's not why I started this channel. That's not why I make these videos. The reason why I started this channel, the reason why I make these videos is because I know that the system is preset to keep you out, to make you fail. And that's why I started this channel, to show you not how, like I said, it's not to show you how cool I am. It's to show you how someone going through proper procedures and going through all the right channels is just going to be set up to fail everywhere they turn. And even if they go through alternative methods, they're going to be set up to fail there as well. And that should alarm people. When we brag about having rights and freedoms, and we go to stand on and use those rights and freedoms, and we just get stonewalled or railroaded or whatever, And you can't get in there and make changes yourself because the whole system, like I said, it's preset to keep you out. So the people that run the show, the people with the highest powers of public trust, are going to keep you out. They can continue to commit crimes. They can continue to be corrupt. And there's nothing you can do about it. And that's why I have a YouTube channel. That's why I make all these videos, is to show you that our system is set up to keep you out and to protect themselves from people like me. So I made a complaint to the Office of the Chief Judge about the Honorable Judge Loretta Chaperone acting angry and impatient, making wild and outrageous accusations that I was slandering people. And I can't publish the entirety of the results of this complaint because a lot of it goes into the audio recorded by the courts of the settlement conference. That's right. The entire settlement conference hearing was audio recorded by the courts from start to finish. And I knew this going into it. So they're allowed to record it. So when I make this complaint, they reviewed all of the audio and they discussed this in the email. And I have to leave this out. I think you know why. So I'll just go into some of the points that they make about my complaint that doesn't actually go into the audio recordings that they have. Quote, "Review of the audio recording does not support your assertions or the conclusion that Judge Chaperone acted in a manner that could fairly be described as judicial misconduct. In summary, as you have not raised a matter within the Chief Judge's authority under the Provincial Court Act, we are unable to assist you. Thank you, Office of the Chief Judge, for completely proving my point." Thank you. Say, speaking of complaints, one of my followers made a complaint to the Law Society of British Columbia about Mr. Barber's conduct, where he followed to threaten me home. Twice, while following me out of the court building. So I'm going to get back to my little December/January break here. Have a Merry Christmas and a Happy New Year. We'll go ahead and put those results out in part 26, so stay tuned. If I'm not in prison, if I haven't been shot and killed, if I haven't gone missing, if I haven't disappeared, we'll see you in 2022 with part 26. Or who knows, maybe we'll see you just after Christmas before New Year's with part 25 3.0. Who knows? Thanks for watching.
Especially in lieu of the way the world is going now, in lieu of world events nowadays. Does this come off? I'm sure it's still on, that's fine. Okay.
Hello, good citizens. Welcome back to Documenting and Exposing West Shore RCMP. This is part 26. This video will be a follow-up video to part 21. After watching part 21, one of my viewers, named Kevin, set out to make a formal complaint to the Law Society of British Columbia. And Kevin made a conduct complaint against the prosecutor at my trial, Nicholas Barber. So Kevin got in contact with me and I gave him the information he needed to make that formal complaint. And shortly before Christmas in 2021, Kevin got the results of his complaint. And of course, as we all know, as you all remember, basically what the basis of Kevin's complaint was that Mr. Barber, the prosecutor at my trial, followed me and told me that he was going, if I didn't want to listen and I didn't want to learn, he was going to follow me home. He actually said this twice. And he said it in front of an independent witness, and he said it in front of a sheriff. He also said this within earshot of many other court staff. And Kevin, being the gentleman that he is, the good citizen that he is, he felt compelled to make a formal complaint. After seeing part 21, he was shocked and appalled with all the acts, the British Columbia laws that Mr. Barber broke, the criminal code sections that Mr. Barber broke. If you want to know more about the British Columbia laws and the criminal code violations that Mr. Barber committed on that day, just rewatch part 21. I go through it extensively. Won't go through it here again. So if you don't know what acts and laws he broke that I'm talking about, go watch that. So after waiting patiently a few months, Kevin got this response from the Law Society of British Columbia about his complaint about Mr. Barber threatening to follow me home. And the person who wrote this up, her name is Frances Gropper. And she writes to Kevin, she says, "Dear Kevin, I have completed my assessment of your complaint. Thank you for your time and effort in bringing your concerns to the attention of the Law Society. We rely on members of the public to alert us of any concerns about lawyers so we can regulate the legal profession in the public interest. Your complaint arises from a YouTube video which you watched and provided to the Law Society. You allege that Mr. Barber made threats against a person in the video's recording. In your complaint, you clarify that you are not affiliated to the alleged conversation with Mr. Barber. While I do not dismiss your version of the events, the evidence you have provided is insufficient to establish that Mr. Barber is in fact the person being recorded. Further, the recording was made in direct contravention of the court's policy on use of electronic devices in courtrooms. Wrong! The recording was made outside of a courtroom, hence why it's still on YouTube. Even if I were to accept your evidence that Mr. Barber is speaking in the recording, I disagree that the comments made amount to threatening, intimidating, or harassing behavior. Lawyers are expected to be courteous and civil and act in good faith with all persons who they have dealings in the course of their practice. The Supreme Court of Canada made a determination regarding incivility in Gruy versus Law Society of Upper Canada. One of the court's findings was that the conduct of a lawyer must be very serious and beyond mere rudeness to constitute professional misconduct. In my opinion, the conduct alleged does not meet the threshold to constitute a discipline violation. For the reasons described above, I have concluded that there are no facts provided supporting a finding of a discipline violation. Accordingly, I have closed the file pursuant to Rule 3, yada yada yada, of the Law Society Rules 2015, which reads, the Executive Director may decline to investigate a complaint if the Investigative Director is satisfied that the complaint does not allege facts that, if proven, would constitute a discipline violation. We will provide Mr. Barber with a copy of your complaint and a copy of this letter for his information. And then she goes on to say you can make a complaint to the ombudsperson if you want. And Kevin asked about that, and I reminded him about the video that I made where I had made a complaint to the ombudsperson. It was a very urgent complaint. It was a threat of being held in prison, having my bail revoked. So it was an extremely urgent complaint. And if they're going to take 15 months to respond to a complaint, considering that the complaint is about they're about to throw me in prison, it's a useless agency, in my opinion. So, yeah, anyway, that's what the Law Society of British Columbia has to say about Mr. Barber being a prosecutor and following the accused and threatening to follow the accused home, not once but twice. It's not threatening. It's not intimidating. It's not harassment. What are you talking about, Kevin? So, who is the Law Society of British Columbia? Well, let's go to their website. Let's check it out and see what they do. Yeah, here it is. This website's like a breath of fresh air. So it says here on their homepage here, it says that protecting the public interest, ensuring the independence, integrity, honor, and competence of BC lawyers. And sure enough, they have a section called About Us. So what do they say in About Us? Well, it says here, the Law Society of British Columbia ensures the public is well served by legal professionals who are honorable and competent. We regulate the legal profession in BC. protecting the public interest in the administration of justice by setting and enforcing standards of professional conduct for lawyers. We also bring a voice to issues affecting the justice system and the delivery of legal services. So, thanks, Law Society of British Columbia. So what do you guys think about the Law Society of British Columbia saying that when one of their prosecutors is prosecuting an accused person and they follow that accused person and then tell that person as they're following them, I'm going to follow you home, not once, but twice, in front of an independent witness and a sheriff? Yeah, according to the Law Society of British Columbia, that's not threatening. That's not intimidating. That's not harassment. That's not contrary to any of the British Columbia acts or laws or sections of the Criminal Code of Canada. Oh yeah. Just imagine Just imagine showing up at a courthouse anywhere in Canada or or anywhere in the world and just randomly telling people, "I'm going to follow you home. If you don't want to listen, you don't want to learn. I'm going to follow you home." You get zapped and strapped like instantly. Boom, you're Dunskies. You're in a cell. You're facing criminal charges. You're not going anywhere for God knows how long. Do you have any idea what kind of serious criminal charges you would be facing if you went to a courthouse and started telling people that you were going to follow them home? Whether you knew them or not? Well, thanks, Law Society of British Columbia, for protecting the public interest in the administration of justice and by setting and enforcing standards of professional conduct for lawyers. Thanks, eh? Great job. Now, I also found it interesting in this complaint process that this person, Francis Gropper, that did this assessment on Kevin's complaint, didn't interview anyone, any of the witnesses or myself or anything. And I really thought that was odd until I, of course, realized that it didn't matter. It didn't matter that somebody independent witnessed it, because a prosecutor threatening to follow an accused person home, that's not intimidation. That's not harassment. That's not threatening. So yeah, it would have been a waste of time to interview any witnesses or myself, because according to the Law Society of British Columbia, when a prosecutor threatens to follow the accused person home and is following them, that is completely acceptable conduct. Like, why on earth, Kevin, would you make a complaint about this? Why on earth would the Law Society of British Columbia step in and discipline Mr. Barber over this? Nope, Law Society's totally okay with this. Anyway, so that's that. So that's fine. That's nice. Let me know in the comments what you guys think about the Law Society of British Columbia. So anyways, as the timeline goes, a settlement conference was rescheduled. As in the last one, the judge ordered all parties must appear in person. So I'm back in court for that rescheduled settlement conference where everyone's supposed to appear in person, and the court clerk calls the matter before the judge, and I look around and I'm saying to myself, hey, where is everyone? I'm the only one here. It's me and the court clerk, a judge, and a couple of sheriffs. Where's the defendants that were all supposed to show up in person? Oh, the court clerk's dialing them up on the phone. Oh, they're not appearing in person. Oh, isn't that contempt of court? Wow, defying a judge's order. A lawyer for the Department of Justice, a lawyer for the RCMP, and a high-ranking member of the RCMP, all defying a judge's order to appear in person. Contempt of court. Wow! So, I could have said something to the judge and said, hey, but, how many more days off work do I need here, right? So I just said, you know what, let's just move forward and see what we can do here. So with that judge at that settlement conference, of course, nobody wanted to settle. So we didn't settle. So we had another court date. So I go to the JCM, the Judicial Case Manager. I go into her office. She's a Justice of the Peace. And I inform her that the judge instructed me to come here to set another date for a applications hearing. And this justice of the peace is also responsible for setting the dates and times for all the parties and cases. And so she says to me, she looks at me and she says to me, "Where are the defendants?" I said, "Oh, they defied the judge's order. They're not here today." She goes, "Oh, they were supposed to be here in person." I said, "Yeah, I know. They defied the judge's order. Isn't that contempt of court?" She goes, "Oh." So anyways, we sat down and decided to chat over this via email. And I tried to get the justice of the peace to get a little something on the record through the email here about the defendants not showing up. So I asked her, I says, "Also, question for your worship. In considering making a complaint about the defendants' non-attendance as ordered in August 2020 at Western's Community Courthouse, would a complaint be better served towards the Western Community staff or the Department of Justice or both or someone else? Thank you in advance." To which she did not respond directly to. Smart move, your worship, smart move. So what do you guys think about a lawyer that works for the Department of Justice, a lawyer that works for the RCMP, and a high-ranking member of the RCMP himself defying a judge's order and not appearing in person? As ordered. Whoa. Oh yeah, you see now why they don't allow you to record in court? You see why they don't want you to record anything? You see why these settlement conference hearings are off the record? Well, if you were wondering before, now you know why. So anyways, we set another date down the road for another application hearing, and it's a very long hearing. It's a very long transcript. I'm still waiting on the transcript, but that's going to take a while to make probably 2 videos out of. And if y'all wouldn't mind, just before we go, give Kevin a shout out in the comments. Give him a hell yeah. I personally want to thank you, Kevin, for at least trying to make this complaint happen. So thank you, Kevin. And this is one thing that I wanted to show on my YouTube channel, is it doesn't matter who makes the complaint. You know, I always say, oh, they never take my complaint or whatever, right? But here we are, there's a very serious issue. Someone else makes the complaint, has all the evidence, and that's not intimidation, that's not threatening, that's not harassment. So there you go. So thank you, Kevin. So that's all I got for you for now. Until part 27, thanks for watching.